I'm talking about a recent decision which I think is a bit of a hot topic in lease world at the moment. That is the Court of Appeal's recent decision in Wilmot Forests. It was originally the subject of a decision before Justice Davies. It was appealed to the Court of Appeal and heard, the decision was handed down late last year, and there is an application for special leave to appeal the Court of Appeal's decision that's being heard by two judges of the High Court tomorrow. That won't, if special leave gets up, the special leave application is successful, that won't overturn the decision. There may be a further hearing down the track. However, if the application for special leave is unsuccessful, then the Court of Appeal's decision will stand. Now, to give you the very brief overview of the Court of Appeal's decision is this. The Court of Appeal said that a liquidator appointed to a landlord company could use the disclaimer power under the Corporations Act to unilaterally extinguish all rights held by a tenant of the landlord company. Right. So that's the sort of threshold issue in this case. Now, to give you some of the background, Wilmot Forests was yet another of the forestry and agricultural managed investment scheme companies that's fallen over in the last few years. Most of you would probably have heard of names like Environinvest, Timbercorp, Great Southern, Tasmanian Forestries that have all, and Elders that are having some trouble, although haven't tipped over yet. And of course Guns in the last few years as well. Now Wilmot was, like most of those, a large group of companies. There was one company that was appointed as the responsible entity, and there were also landowning companies involved. Now, a managed investment scheme is, for those who aren't aware, is a form of statutory regulated trust. It's effectively a trust regulated by Chapter 5C of the Corporations Act. The responsible entity is the form of trustee who has some additional duties imposed on it